at the Supreme Court this week. The Supreme Court reiterated that a certificate of registration from the Department of Labor and Employment, or DOLE, does not automatically mean a manpower agency is engaged in lawful job contracting. In a decision written by Associate Justice Jopar B. de Maampao, the SC's Third Division held that Nozomi Fortune Services, Inc., a manpower agency, engaged in labor-only contracting when it hired Celestino A. Naredo and assigned him to Samsung Electronic Mechanics Phils as a production operator. The court said determining whether a manpower agency is engaged in legitimate job contracting or labor-only contracting requires looking at all the facts and circumstances. A DOLE certificate of registration may help prevent assumptions of labor-only contracting, but it does not serve as conclusive proof of legality. The Supreme Court upheld Sections 6 and 29 of Republic Act No. 9136, or the Electric Power Industry Reform Act, or EPIRA, stating that electricity generation and supply are not public utility operations, but are still subject to the regulation of the Energy Regulatory Commission, or ERC. The court ruled that to be considered a public utility, a business must provide a service essential to the general public. Power generation and supply companies offer their services to limited customers and do not deal directly with the general public. However, they remain under government regulation because the EPIRA expressly provides safeguards against abuse or irregular activity. The Court en banc also upheld Section 34 and Section 24, Paragraph B, Subparagraph 2 of the law empowering the ERC to fix and approve the universal charge imposed on electricity end users, and Section 43, Paragraph F, which gives the ERC the power to fix charges to allow distribution utilities to recover their losses. The case stemmed from a petition challenging the constitutionality of certain EPIRA provisions. The ERC earlier authorized Manila Electric Company, or Meralco, to recover its generation costs from consumers on a staggered basis. The Supreme Court has approved the rule on family mediation in a resolution dated November 5, 2024 in AM number 24-02-06-SC. This initiative aims to address the emerging need for family mediation, both domestic and international, enhance the efficiency of family courts, reduce court backlogs, and promote the best interests of the child. The rule also introduces innovations in dealing with family cases. Family mediation involves a mediator, acting as an impartial third party who facilitates the resolution of family disputes and helps the parties in reaching voluntary agreements. The rule took effect 15 calendar days after its publication. It was published in a newspaper of general circulation on December 14, 2024. The Supreme Court reiterated that disciplining children, even if it results in physical injuries, does not automatically amount to child abuse. To be considered abuse, there must be clear intent to harm a child's dignity. In a decision penned by Associate Justice Josep Y. Lopez, the SC's Second Division upheld the conviction of a father for child abuse after subjecting his 12-year-old daughter and 10-year-old son to violent and excessive discipline. He was found guilty of violating Republic Act No. 7610, or the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act. The SC emphasized that while parents have the right to discipline their children, such measures must not be violent, excessive, or disproportionate to their misbehavior. But without the clear intent to harm the child's dignity, the offender cannot be held liable for child abuse but can be charged with other crimes under the revised Penal Code. The Supreme Court has partnered with the Korea International Cooperation Agency, or KOICA, Philippines, in conducting a preliminary survey aimed at modernizing court systems in the country. This partnership will create an electronic verification and case and evidence management system, digitize court records, and train court personnel. The project seeks to reduce case backlogs and streamline adjudication processes by leveraging cutting edge technology. KOICA, a Korean governmental organization for official developmental assistance, will lead efforts to introduce advanced systems inspired by the Republic of Korea's modern judicial practices. Applications for the 2025 bar examinations has commenced starting 8 o'clock in the morning of January 8, 2025, and will run until 3 in the afternoon on March 17, 2025, based on the announcement from the Office of the 2025 Bar Examinations Chairperson, Supreme Court Associate Justice Amy C. Lazaro Javier. For bar bulletins and other information about this year's bar exams, you may visit the BAR 2025 microsite at the Supreme Court website, sc.judiciary.gov.ph. In line with its efforts to streamline court processes and decentralize some functions of the Office of the Court Administrator, the Supreme Court held information drives for the Office of the Regional Court Manager, or ORCM, in Judicial Region 9 in Zamboanga City on January 6, led by Associate Justice Antonio Tico Jr., Judicial Region 10 in Iligan City on January 8, led by Associate Justice Japar B. de Maampao, and Judicial Region 5 in Legazpi City on January 10, led by Chief Justice Alexander G. Gismundo. The court also held a user training workshop for eCourt PH version 2 at the Judicial Academy Philippines in Tagaytay City on January 8 to 9, and a dialogue in San Fernando City, La Union on January 10. Lastly, the Supreme Court launched the Regional Mental Health Unit at the Office of the Regional Court Manager for Judicial Region 1 in La Union on January 10. And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.